So Cormac indicated that I should start off a deum qui laetificat juventutem meam quies tuus deus. He suggested I start off with my lines from last night. So, most of you were here last night when they gave me a cameo in this extraordinary production of People versus Phillips. This was not an easy thing for me to do, but when Cormac and Joe and Marion ask you to do something, you lock it on your calendar, you build all sorts of other things around it, and you have no idea how my calendar works. It's all kinds of things concatenate out when people you love call you a year in advance and say, this is important, and you realize it is. And this weekend became one of those locks. But if you'll indulge me for a second, just to give you a sense of then what happens. So this then becomes the weekend where we bring in the last group of students and their families that are being admitted to NYU Abu Dhabi and NYU Shanghai. It's the weekend we have the final round of the NYU World Debate Championships for high school students, which I will judge later in the day. It becomes a weekend for two of my Saturday sessions, and my schedule, which began this morning with a call with the administrators in Abu Dhabi at 6 a.m., because that for them was the afternoon, goes on. But everything got built around this. And when you think of it, we were talking, Joe and I, just a few moments ago about playing this role, because not to steal his speech, but he said his speech was going to be to thank me for my speech. I said, I'm not here, I realize, in the role I sometimes play, which is the corpse in Finnegan's Wake. The reason for the party. I'm by no means the reason for the party, but I am here in a different function that people like me sometimes play, which is the blessing function, which is good because there's always been this. I've always been an inch away from being a Jesuit priest. So it's pleasant. I used to refer, and my wife used to refer to the law school in which we are as my parish. And when I resisted the idea of taking this assignment, I said to the trustees, I was put on earth to be a parish priest, not a cardinal. I don't want to become a cartoon, which is much the life of a university president, especially these days. But to bless is good. And the Irish, and I'm an O sexton. I really am an O sexton. The O was taken off at Ellis Island 2 generations ago, but I visited the family farm in the west of Ireland, where we still are O sextons. The Irish bless with stories, so you'll excuse me as I take you in a quite serpentine route that connects back in just a few minutes. So last night we were doing People versus Phillips here, and I had locked the night, even for a brief appearance, because it was such an extraordinary event. And an event, I have a PhD in religion and of course also a doctorate in law, and one of my 2 specialties has been the intersection of religion and law and religious liberty and law, and 3 of the 4 courses I now teach are on the intersection of religious liberty and law, and I teach them to 3 very different groups of students. I teach them to American students, by and large, here, who think the only way to relate church and state is the way we discussed last night, which is this complete separation. And then I teach it to a group of Muslim students in Abu Dhabi, all Emirati, who have a tolerant society, and you can have Shabbat dinner, as we do in Abu Dhabi, or you can go to Mass. But they have a state religion, and they wonder why you would separate church and state. And then I teach it a 3rd section of it to a group of students who come to NYU Abu Dhabi from around the world. So I care about the issues that were here last night, and I had committed myself. So I didn't accept Rachel Robinson's invitation to go to the private screening of 42 last night. Now, this is hard for me because on my academic gown, I have a little circle with the number 42. And I'm very proud of the fact that Rachel Robinson is a PhD from NYU and an honorary doctorate. And Jackie was my childhood hero, and I've known Rachel for 50 years because of a connection of my dad with the Dodgers. This O Sexton here you're looking at, I know this is a convention of historians, and I think only Bill Nelson, my dear friend, knows this. Maybe Laurie does. But this O Sexton, and I will try to get back later in the day. I do have this schedule, but this is such a great day. I actually myself am a historic figure. This is something very few people know, but you're looking at the Jackie Robinson of the B'nai B'rith Little League. I broke the religion line just a little after Jackie broke the race line in baseball. Now this connects through my opening, Deum qui latificat juventutem meam, because at a Jesuit high school in Brooklyn, where I was formed, an Irish Jesuit priest, a great man, still alive, a mystic, a progressive, wrote on the blackboard in 1956, extra ecclesia nulla salus. Outside the church, there's no salvation. And when I went up as the person that had broken the religion line, and asked him, I'm not going to use his name, and asked him whether that meant my best friend Jerry Epstein could not go to heaven, he said to me, unless you baptize him, he will not go to heaven. Now this was before the West Virginia primary and Kennedy's presidency and John the 23rd and the Vatican Council. Fortunately, I had extraordinary teachers who, even at that high school, were beginning to prepare me for a different mindset. And my experience in the B'nai B'rith Little League did that. And I later would marry the most magnificent person I ever met, who was Jewish. And although she adopted the 6-year-old of whom I was a single parent who had been baptized, we raised him Jewish. And when he married an Italian Catholic to honor her, Danielle converted to Judaism on September the 11th, 2001. She was on her way to the conversion when the first plane flew over their head. And we raised our daughter Jewish, and of course, Jed and Danielle's 3 daughters are Jewish. So my Irish Catholic brother-in-law, my sister's husband, says, not since Abraham has a Gentile begat as many Jews as John. Now, why do I connect this to this morning? I connect this to this morning because in this concatenation of diversity that is life, when I came here in 1981 and moved up to the attic of this building where Bill Nelson was, I began, because I stayed late at night, to frequent, just grab some food on the way home from an Italian restaurant across the street, a little bit closer to 6th Avenue, called Volare. And I was a very junior professor here, but there was a couple that haunted a booth there by the name of Lou and Loretta Glucksman, an Irish Catholic Jewish couple. And maybe because Lisa and I were an Irish Catholic Jewish couple, or maybe because they were just unbelievably aware of NYU, but they would call me over to the table, and they were a hand-holding couple, and we were a hand-holding couple. I'm very proud of the fact that after 3 decades of being more in love every day, people would still come up to me and Lisa and say, you must be newlyweds just by observing us. And that's the way Lou and Loretta were. And we would share conversations, and it was an odd thing that a trustee and his wife and a junior professor and his wife would be, and of course they were a different generation from us too, you know. Lisa was 10 years younger than me. But a deep friendship, one of those couple friendships emerged, and we didn't have a lot of couple friendships within the NYU family. Our couple friendships tended to be outside the NYU family. So for me, 20 years of what I heard first become a gleam in their eye. I mean, we would talk about this in Volare, an Italian restaurant, Jew and Irish together, before it became a reality, and then finally 20 years ago it became a reality, and it's a wonderful thing. And to see this weekend and the 5 events that are planned, and even if you look at the events, if you read the letter that you wrote at the beginning, you make the point that those events are Europe and America and the globe, and of course that is the way the Irish have always been, fully open to all of life. And to just bring it back full time, the way these things are planted, even as I was being told extra ecclesia nulla salus, I was being led through Joyce by a great teacher. And I was taught, if I were to summarize the education that this great teacher, who the Jesuits gave to 12 of us for an hour a day, 5 days a week for our sophomore, junior, and senior year. Why they picked the 12 of us, I don't know. But this extraordinary man was just given to us for a course they didn't name. They just called it by his name, his first name, Charlie. And Charlie's maxim was, play another octave of the piano. If there are notes you haven't touched, if there's a food you haven't tasted, if there's a music you haven't heard, if there's an experience you haven't had, as long as it's legal and moral, try it once. And he knew there were limitations on us. When he showed us the pyramids at Giza, and we did the history and read the Shakespeare, and he said, boys, you will never see these pyramids because you can't drive to them. We were poor boys in Brooklyn. But there are pyramids south of here, boys. You just haven't heard of these pyramids because the goddamn British didn't rob these pyramids for their museums. And you can drive to them, boys. So he was planting the seed in the Irish tradition of being open to the whole zest of life. And in a way, that's what we celebrate today, and it's what we celebrate in Ireland House. So God bless you. May the wind always be at your back.
Give me 2 minutes, all right? Because I'm supposed to say something, all right? I can.
Please.
Oh, you want to thank him? You heard, anyway, I'm thanking him as he's going out the door, all right? Listen, I'll just be very quick. I'm Joe Lee, I'm director of Glucksman Ireland House, and I was on the program, which is why I popped up there. I'll be very brief. I just want to say one thing, and it's about last night. I found last night absolutely fascinating, absolutely riveting in terms of something that I had no exposure to before. I'd never, like I hadn't known of the trial before Marion Casey actually brought it to our attention. And I thought it raised so many issues, and what it brought home to me in particular was the centrality of the Constitution in American legal thinking, which you may say that's self-evident, but it wasn't self-evident to me, and the way it was worked into the excerpts last night, I thought was a revelation to me. The only other thing I want to say, and this is why I'm really up here, I'm totally out of order, I'm quite sure, protocol-wise, because the thanks will be expressed at the end. Marion last night thanked a number of people for a number of things. There will be thanks at the end, but I want to say that without Marion Casey, this wouldn't have been happening. If it weren't for her imagination and her dedication, it wouldn't have happened. And she goes beyond the call of duty so normally in Ireland House, just so normally. She thinks it's normalcy. It is absolutely exceptional in my experience in terms of devotion to Ireland House and devotion to NYU. So I just want to put on record my appreciation of her contribution. And now, Laurie, yourself, okay?
Good morning. I'm Lauren Benton. I'm a professor of history and dean of the graduate school here at NYU and an affiliate professor in the law school. So this event and this panel brings together, for me, subjects and institutions within the university that are very dear to my heart. The subject of history and legal history in particular, Ireland House, which always does everything with great style and great humor, and the law school, which is with its wonderful faculty, and they actually also have a great sense of humor. So, although they're not known for it, but I can vouch for it. So I'm very pleased to introduce the presenters for the first panel. The title of the panel is People v. Phillips in the Context of 19th Century Constitutionalism, Religious Exemption, Evidentiary Privilege, and Catholic History. And we have a very distinguished series of panelists. I'm going to introduce them all at the beginning so we can move from one to another, and we hope to have, they'll each speak for about 15 minutes, and we'll hope to have time for some questions and comments from the floor at the end. Martin Burke is Associate Professor of History at the CUNY Graduate Center and is the author of numerous works, including Piecing Together a Shattered Past, the Historical Writings of the United Irish Exiles in America. Jason Duncan is Associate Professor of History at Aquinas College, and he's the author of also many works, including Citizens or Papists, The Politics of Anti-Catholicism in New York, 1685 to 1821. Peter Gailey is Professor Emeritus of Political Science at Canisius College, the author of, among others, Ordered Liberty, A Constitutional History of New York, yes. I'm especially pleased to introduce my friend William Nelson, who's Judge Weinfeld Professor of Law at NYU. It would take me a very long part of the day to list his works, but I should signal that he's most recently at work on a 4-part series on the history of the common law in colonial America. And Thomas Shelley, who's Professor Emeritus of Theology at Fordham and the author of The History of the Archdiocese of New York. So please welcome our distinguished panelists, and some of them will sit and some of them may come to the podium, and welcome.
Thank you. And I want to express my gratitude to Professors Casey, Walsh, and Lee. It's nice to be back at my almost mater. I attended NYU for 2 years in the last millennium, but Professor Sexton is gone. We can talk about that later. I've entitled my short presentation this morning, Catholic Questions in the Early American Republic, and it's drawn from a larger book that I've been working on too long on popular, legal, and learned anti-popery, and then Catholic anti-Protestantism in the 18th and 19th centuries. The general narrative of the Catholic community in the United States is a narrative of oppression. The Catholics arrive, they're oppressed, they continue to be oppressed, the nativists make it worse, and then the miracle of the 2 Johns, the 23rd and John Kennedy in the 1960s, begins to change that story. While I'm not taking too much in objection to that, there's a different story to be told. 18th, 19th, and 20th century Catholics in the United States, nay, on both sides of the Atlantic, were also belligerents in a large debate over the legitimacy of liberal democracy, of freedom of the press, and freedom of religion. In the United States, American Catholics would be major forces arguing that, in fact, while the United States should stay liberal and democratic, it also should convert to Roman Catholicism, and American Protestants, by and large, objected to these positions. Let me then turn to my remarks. The American Revolution transformed the legal and political status of members of the tiny Roman Catholic community. It's about 1% of a population of 2.5 million, give or take, in 1775, 1776. Thank you. Okay. Fiat lux. Okay. Although fear of popery, say, for example, the Quebec Act, was among the causes of the rebellion. Subsequent events would diminish the power of anti-popery in post-colonial America. In allying with France and Spain, and in redefining liberty in opposition to their British heritage, American Republicans moved anti-popery from the center to the margins of public life. When establishing new governments, they guaranteed freedom of conscience and worship to all citizens, and removed most disabilities on religious minorities. Though historians continue to argue over how radical the American Revolution might have been, it certainly was so for Romanists. Unlike their co-religionists in the British Isles, most particularly in Ireland, Catholics in the United States expected to enjoy equal rights. Yet the rhetoric of liberty and the realities of Americans' post-revolutionary religious settlement did not always correspond. Romanists were free to worship, to vote, to serve on juries and in the militia, but they were still barred from holding important elected positions in a majority of states. By the close of the 18th century, 2 of the original 13 states had removed such barriers. None that joined the Union after the Constitution would introduce them. However, restrictions remained in the better part of New England, in New Jersey, and in North Carolina, in some cases well into the 19th century. New Hampshire's Constitution bars Roman Catholics from serving as governor up to 1877 or 1878, and Rhode Island, which actually never had a constitution, they continued with their colonial charter, had on its books at least prohibitions against Catholics holding any office into the 20th century. Please don't tell that to anyone elected in Providence. In New York, the transition from papists to citizens that Professor Duncan has chronicled so well in his book came to an end in 1806 when Francis Cooper took his seat in the Assembly. But the continued presence of tests and oaths prompted laymen such as Philadelphia's Matthew Carey and clergymen such as John England of Charleston to suggest that a, quote, Catholic question, unquote, in America still remained to be settled. For those of you wondering about how this would square with the federal Constitution, both Section 3 of Article 4 and the First Amendment to the Constitution, those dealt solely with the federal government. Religious establishments continued in Connecticut and in Massachusetts, and I don't want to suggest here that these restrictions against Catholics holding office were solely directed against Catholics. They were directed against atheists, all 2 or 3 perhaps in the 18th century, Jews in a number of states, only Protestant Christians, and a number of states, Unitarians were barred as well. Theological and ecclesiological objections to Romanism also seem to have diminished, but not disappeared in the Revolution's wake. Despite the expectation of many, Thomas Jefferson and James Madison among them, that religious liberty would encourage social harmony and ecclesiastical convergence by removing the basis of strife, the separation of church and state opened new spaces for interconfessional confrontations. With these, appeals to reason replaced the legacies of legal coercion. Denominational competition, then, would produce more in the way of controversy than concord in the New Republic. Print and public disputes and debates between Protestants and Catholics began in 1784, when the Reverend Charles Wharton, a Maryland Jesuit who had embraced the Episcopal Church, or perhaps found true religion, published a letter to the Roman Catholics of the city of Worcester. In this text, Wharton explained his process of conversion and also urged his readers in England and the United States to consider the errors of popery and to embrace the truth of the Reformation. John Carroll, his first cousin and fellow Jesuit, who at that point was superior of missions in the new United States, answered with an address to the Roman Catholics of the United States in the same year. Carroll took pages from standard controversial manuals, went after his cousin point by point, and then pointed out the errors of Protestantism and the truths of Romanism. Wharton then responded with a reply to an address of the Roman Catholics in 1785. The tone of these exchanges was measured. It wasn't militant, Both Wharton and Carroll employed the tools and the text of learned anti-popery and anti-Protestantism. So too would subsequent controversialists in the late 18th and early 19th centuries, including another Jesuit, the Reverend Anthony Coleman. Although the court's decision in the People v. Phillips appears to have prompted no objections, I'll defer to Professor Walsh on this, but I can simply find no one in New York City in the wake of this who seems at all perturbed. The publication in 1813 of William Sampson's trial report did. The Catholic question in America included a 112-page appendix by Coleman entitled A True Exposition of the Doctrine of the Catholic Church, Touching the Sacrament of Penance. Coleman went through the articles of the Council of Trent, through the Church Fathers from Eusebius on, and through a number of standard 17th and 18th century Catholic manuals, including Richard Challoner's and John Gother's 18th century controversial pieces, and pretty well lined out what penance did. He, however, opened it with a short preface, and in that preface he would make an argument he had made previously and would continue to make. That is to say that Catholics in the United States, Protestants in the United States, excuse me, had not embraced Catholicism due to the perfidies of Protestant ministers. If Catholic truth was made obvious to an American Protestant readership, they would embrace the true church. That they had not was due to what he would refer to as, quote, prejudice, unquote, and he sought to undo that prejudice with the publication of the Catholic Question. He then hoped to counter gross misrepresentations that prejudiced the minds of American Protestants with Catholic apologetics. The following year, Charles Wharton, once again, rejoined the ranks of controversy with a short answer to a true exposition of the doctrine, which presented standard Protestant arguments against the scriptural basis and the social consequences of confession. Wharton, the ex-Jesuit, was particularly incensed that Coleman would refer to Protestant ministers, like himself, being involved in misrepresentation. Wharton went through the standard Protestant positions against both penance as a sacrament and then auricular confession as a practice. And as was standard for most Protestant texts, he moved from theological matters to social matters. Protestants would argue in the 17th, 18th, 19th, and into the 20th century that the social effects of penance and of auricular confession would be detrimental, and for Wharton, especially to an American Republican citizenry. How so? Because by simply absolving people of sin, the priest in the confessional, in fact, was allowing crime, disorder, and subversion to go on and on and on. Wharton, of course, did not want to stop auricular confession legally as a practice, but Wharton was extremely concerned that, in fact, auricular confession would be accepted by Americans in general and not seen for the menace that he construed it as. A Charleston Catholic cleric, Simon Felix Gallagher, entered the fray in response to Wharton with a brief reply to the short answer of a true exposition in 1815. And once again, Gallagher, a Maynooth graduate actually, I think he's probably the first Maynooth man who makes an impression in the United States, also a professor at the College of Charleston. Gallagher would respond to Wharton with, once more, the standard Catholic answers to Protestants, and would argue, in fact, that auricular confession would have a beneficial, not a dangerous effect on American Republic audience. Wharton brought this opening episode of what would become a prolonged debate over the implications of auricular confession in America to an end in a text called Some Remarks on Dr. O'Gallagher's brief reply 2 years later. The Catholic question that engaged the Reverend Coleman, Wharton, Gallagher, and their readers was not about how suitable Romanists might be as subjects or citizens. Rather, it was about the ethical and moral implications of Catholic doctrine, discipline, and devotions in the new American Republic. This then was a theological, not a legal debate. We heard DeWitt Clinton last night referring to his decision in the People v. Phillips in terms of it being legal, not theological, but in fact, most Americans who would be aware of this case would follow it in the 18 teens and into the 1820s in theological, not legal terms. Yet by the early 1830s, the political and legal consequences of popery would once again emerge as a matter of contention, especially here in New York City. This is a subject perhaps for a future symposium. John Hughes, who would become Bishop and Archbishop of New York, would deliver an annual lecture on St. Patrick's Day, which he called the downfall of Protestantism, unquote, part of John Hughes's strong ecumenical outreach. I should note in closing that Coleman produced a satirical attack on Martin Luther during the tercentenary of the Reformation in 1817, and a more subsequent critique of Unitarianism when he was president of Georgetown in 1821. In 1824, he moved to Rome and a chair of theology at the Gregorian University. Among his students was Paul Cullen, who, as Cardinal Archbishop of Dublin, would promote an anti-Protestantism far more polemical than his professor's measured apologetics, and far less ecumenical than the United Irish Irenics of William Sampson. Thank you.
Professor Duncan.
Good morning. Thank you, Professor Benton. I'd like to express my thanks to NYU, Professor Casey and Lee. My parents are here from Albany, Kay and Dave Duncan. My friend Mike Pfeiffer, a grad school friend. He's at John Jay, who tried to keep Catholics from achieving religious liberty in the 1770s. I don't blame Mike for that, but anyway, he's here with us today too. Last night, watching the reading, the brilliant performance by the actors, it was astonishing to see Andrew Morris and Dennis McCarthy. DeWitt Clinton, of course, he has his own thing, but those two fairly obscure Catholics being brought to life on stage, just amazing. I'd like to find out who that nameless chair of the Board of Trustees was. That's a minor point, but I'd like to know the name of that person. It will add to our understanding of this. So, following Professor Burke, I'd just like to give a brief history of Catholics in New York leading up to the Catholic question of 1813, the Phillips versus the People case. This, Catholics in New York, colonial New York, were in a very strange position. And when I first started doing my research in Iowa in the 90s, I read a few books on early New York, and I was always told the cherry story of pluralism, diversity, toleration. New York is home to a variety of different Protestant churches, a synagogue. And I thought, well, okay, of course, that makes sense. Then I started looking into it, and I stumbled across this event I'd never heard of, Leisler's Rebellion, 1690. I mean, every 5-year-old kid in America has heard of the Salem witchcraft trials. But at the same time in New York, colonial New York, there was a similar witch hunt against Catholics. Now, as Martin just reminded me, Catholics can be belligerents too. I don't want to fall into the Catholics always right, Protestants always wrong dichotomy, but Catholics were chased out of New York unceremoniously in 1690, 91, after Leisler's Rebellion, and their religion was prohibited, expressly prohibited. So the breezy assumptions that New York is a harbinger of the future of the United States, all I can say is I hope not, because for Catholics in New York, it was not particularly pleasant or pluralistic. Catholics that did live there would go to Philadelphia for Mass if they could afford it. There was occasionally it would erupt in strange ways, like the 1741 New York slave conspiracy, where the authorities were convinced that slaves in league with the French and the Spanish and underground Catholics were attempting to burn down their city, and the fact that the first fire was set on March 17th only added to their suspicions, and people were executed, including a priest who was executed as a Catholic priest, which was a capital crime. He claimed to be a renegade Anglican. The authorities didn't buy it. So that was a ghastly sort of reminder of this very strange situation in New York that existed until the Revolution. The revolution is the event that changes it. I think Catholics in America benefited from the revolution as much as any group in the country, and this is not fully appreciated, especially in New York. Before the revolution, there's no freedom. After the revolution, there was. The first churches opened at St. Peter's on Barclay Street in 1786. Without the revolution, eventually, 1830s maybe, when things ease up in England, but we don't know. So it's a huge event for Catholics. Now, it doesn't really start out particularly good. In the 1750s, members of the Whig Club would meet and debate and question the British system. At the end of the meetings, they would inevitably toast the immortal memory of Oliver Cromwell. So that didn't really bode well for Catholics in the Revolution. As the Revolution formally starts 20 years later, once they decided King George was no good, and they were slow to move to that conclusion, but once they reached it, they reached it. And one of the things they accused him of was becoming a Catholic tyrant. So he's not just a tyrant, we've known that for a while now, he's somehow become a Catholic tyrant, and we have to separate. Now, during the Revolution, of course, wars change everything. Revolutions change, but the potential at least to change everything. And for Catholics, suddenly the logic of the war made them less suspect. They weren't necessarily committed. Why would they be, especially in this colony, to the established order? There was no logical reason for Catholics to want to uphold an order which discriminated against them. And they didn't have to be geniuses to figure that out. So in New York, the revolution was quite contested. And the patriots were very eager to look into their enemies. They established a commission for detecting and defeating conspiracies. Okay, it wasn't just the point of detecting conspiracies, you have to defeat them. And so New York had a long list of those who were under suspicion. Slaves, Shakers, Tories, deserters, Hessians, neutrals, robbers, spies, and even Quakers, but no Catholics on the list. So Catholics start to fall out of suspicion. The French alliance helps to move things in that direction. Now, during the war, the aforementioned John Jay, a conservative revolutionary, he expressly tries to prevent Catholics from being included in religious liberty. He wants to maintain that exclusion. He's defeated. Catholics do gain religious liberty, and as we said, they open the church a few years after the war ends. But there's also certain oaths regarding citizenship put into the Constitution for immigrants and potential voters. Now, in the mid-1780s, the church opens in Manhattan. The leading political party in the state is around George Clinton, Irish Protestant from rural New York, and it's rural New Yorkers. I'm not sure what George Clinton's, DeWitt's uncle's role is in this, but it was the anti-federalist who adopted a law, proposed a law to prevent effectively Catholics from holding office in New York. It was, of all people, and this shows the twists and turns this story can take, it was Alexander Hamilton. When I was in grad school, he was clearly one of the bad guys. He was definitely one of the bad guys. Well, and from the perspective of Catholics in New York, he was not. He had a national vision of a new nation, and he had been a Continental Army officer. He had met Catholics in Philadelphia, Pennsylvania, and Maryland, and he successfully defeated this measure. He had that kind of ability. The next year, Hamilton's out of the legislature. His opponents notice that fact. They get that oath of office bill enacted into law. 1790s, this a crucible of American political history and the political identities that are formed. The French Revolution breaks out. The French revolutionaries attack the church. All Americans with political knowledge have some view on this. The Federalists are aghast. They portray themselves as the great defenders of religious liberty, which had a certain credibility to it. The Republicans, they charge, with also some credibility, were hostile to religion. And Catholics, of course, would have noticed that it was their church under attack. So, in the 1790s, it looked as if the Federalists and the Catholics, based on Hamilton's efforts, the law passed by anti-Federalists who became Republicans, the politics of the revolution in France, would lead Catholics and Federalists into an alliance. There's wealthy Catholic merchants at St. Peter's, Dominic Lynch, Andrew Morris, who was up on stage last night, so to speak, and others. But as historians have long noted, the Federalists blew it. They blew it. They were uneasy with immigrants, uneasy with poor people. Irish Catholics struggling to make a living weren't their ideal American citizenship. The other party, the Republicans, the Tammany Society, ironic given the later history of that august group, institution, they were nativist Republicans. But in 1800, as a part of the winning the election of that year, the Republicans led by Aaron Burr naturally organized poor people, immigrants, and in the wards where Catholics lived, the vote went for the Republicans. One Federalist said bitterly afterwards, his party's defeat came from United Irishmen and French and other foreigners in those wards. The Federalist Party never fully recovers from this debacle. And in New York, there begins to be more urban republicanism, different from the anti-Federalist rural sentiment that was strongly Protestant, evangelical Protestant, and anti-Catholic. DeWitt Clinton is at the center of this. I'm not 100% convinced why. He had Irish roots, they were Protestant. His uncle, he was very close to, his group in the 1780s were not friendly to Catholic voters. But Clinton makes something of an alliance, and I sort of set up this dichotomy among Republicans. The nationalist Republicans of Tammany, the Atlantic Republicans of Clinton, DeWitt Clinton especially, United Irishmen, Catholics, and immigrants. Clinton becomes quite a help here. As a young senator, he helps repeal a Federalist law that had extended the citizenship time for immigrants. In 1806, there was a midnight mass at St. Peter's. A mob menaced the proceedings, but as Elizabeth Ann Seton, a future Catholic saint and a convert to Rome, said of the incident, they said it was high time, the cross was pulled down, but the mayor has issued a proclamation to check the evil. So DeWitt Clinton has a history leading up to 1813. Now, he is a slippery figure. He's a Republican who some Republicans detest. He runs for president in 1812. He's kind of a quasi-Federalist, renegade Republican. Eventually, he breaks with Catholics in about 1820 as a Van Buren Republicans make an alliance with them. But for a good part of this, he is of great assistance. Now, the key moment, as I see it, and others have said, is 1806. The Republicans, now an urban party, nominate Francis Cooper for the New York legislature. He's a Catholic. He is well-connected. He's fairly affluent. He's not Irish. That probably helps. He's of German ancestry. He wins an election easily. The legislature will not revoke the oath in which he has to renounce his authority, his connection to the papacy. So, Catholics in New York meet. 1,300 of them, both Federalists like Morris, Republicans like Cooper and others, sign a petition which they send to Albany. The Clinton party in there, including Richard Riker was here last night, and others, successfully overturned the oath. Huge victory for Catholics. They use some of the same arguments Al Smith uses in 1928 and John F. Kennedy uses in 1960. Basically, that it's a spiritual connection. Our first loyalty, politically, militarily, is to the United States. At one point, they said, even if the Pope himself led an army into New York, Catholics would fight against it. Now, that's not likely then. Presumably, it's even less likely now. But the point was made that Catholics were loyal first to New York and the United States. 1807, Federalists and Nationalist Republicans formed what they call the American Party against immigrants, foreigners, Catholics. Somehow, the Atlantic Republicans win. So that is a key moment in this history as well. The War of 1812, as a questioner said last night, is also crucial. It is during that war that Nationalist Republicans dropped their nativist objections to Catholics. Members of the Tammany Society and the Hibernian Providence Society now go to each other's banquets. Unthinkable a few years before. They toast each other. They see the common enemy, Britain, England. So that confluence of events helps end any sort of division between those Republicans and Catholics. Catholics clearly support the war. As one Irish writer said, "We appreciate America. We have found here what was unfeelingly denied us at home." They don't need to be told that their rights in America are not respected in Britain. So in 1813, when the case comes before the court, Catholics had a series of advances over the previous 35 or 40 years. Religious liberty, and then political equality effectively, and then this decision in the court case which further and very specifically protects their religion. So when William Sampson says, in the case, I am not just a friend of Catholics, I am a Catholic, politically at that moment, he was. Thank you.
Thank you very much, Professor Duncan. Now, Professor Gailey.
Thank you. This is on. I'm going to sit this presentation. Does everyone have a copy of the handout I gave you, the listed selected provisions from state constitutions in New York from 1777 to the present? Make my presentation much less boring if you can have those in front of you. I don't have to read them for you. I'm here certainly not because I'm an historian or student of the Irish in America, Catholics in America. I'm here primarily, I suppose, because I wrote a book on the constitutional history of New York. And since that's my expertise, I thought I would focus on something that I could provide that would be most useful to the conference, and that is to give you some idea of the trajectory of state constitutional treatment of religion and Catholics from the beginning till the end. So I hope that these provisions will be helpful in all of the panels that we find ourselves in for the next couple hours. So what I want to do is give you a thumbnail sketch of the treatment of religion, and that turns out to be mostly Catholic religion. That is, it's Catholics that raise most of the issues involving the Constitution after 1777. They're directly or indirectly involved in these provisions. Now, the issue is rarely posed in those terms in the debates or in the document itself. It's always put in the context of the larger question of preserving religious liberty, the principles embodied in the state constitution with things like no establishment and free exercise. Little attention until recently has been paid to state constitutions at all. Now, there are many lawyers who have probably practicing in New York who never read the New York State Constitution. I mean, this is the tremendous difference between our focus on the national constitution and our neglect of state constitutions. But that's my hobby horse. I won't go into it at this point. Suffice to say that one of the nice things about the people working in this field is they were forced or they were driven to look at these cases, these state cases, in some detail for the kind of information it might provide us. And so there is been a resurrection not only among state constitutional students, both political scientists and lawyers, but among historians to work these cases over, and that's all to the good. So let me go through these, making some comments along the way. The Constitution of 1777 has, it obviously is the foundation document, and so you see a great many provisions, a number of provisions here. The first one, Article 35, is the one that disestablishes the Church of England in the United States. You can see very clearly that while we accept the common law, I like the Americans because we had a sober revolution, I mean, a revolution of sober expectations, unlike the French. And there's a great Burkean flavor, I think, to a good deal of the early American understanding of constitutions. I mean, a great deal of the colonial institutions were simply embodied in this new constitution. So we wanted to keep the common law. We wanted to make sure certain things were out. And clearly what was going to be out was any established church. And so right off the bat, Article 35 does that. And then this is the most famous or infamous provision in 1777, Article 38. This is the one that is largely the result of the proddings of John Jay, but also of the bargaining or the debate that goes on between Livingston and Morris on one hand and Jay on the other with regard to how far they're going to go with this anti-Catholicism. So it says, notice, whereas we are required by the benevolent principles of rational liberty, which is a kind of Enlightenment view. Clearly, these phrases are loaded phrases. They have a certain meaning, not only to expel tyranny, but goes through this, but the bigotry and ambition of weak and wicked priests. Professor Welsh points out that Samson, either through inadvertence or a printer's error, leaves this stuff out, because there's a certain irony involved in quoting this passage to protect religious liberty for Catholics, when in large measure the purpose was indeed anything but. So, and Professor Welsh quite carefully refuses to make any definitive judgment in it, but of course we all can make our own judgments about that, a lawyer's brief. Article 39, here's the article that simply says, look, if you want to be a clergyman, that's fine, but if you want to be a clergyman, you have to choose either religion or politics. If you're going to be a clergyman, you can't run for office. And this is all part and parcel of this idea of the concern of these writers of this Constitution about the extent to which religion might intrude itself upon the political realm. Article 40, this one came up in the discussion, in the case. Yes, there was some discussion of it about the Quakers as an exception. And in the Constitution of 1777, the exception is explicitly written in. It's not a court interpretation. The Constitution says that all such of the inhabitants of this state, being of the people called Quakers, as from scruples of conscience may be adverse to the bearing of arms, be therefore excused by the legislature, and do pay to the state sums of money. Now Samson uses it, and they make them pay, you know. Is this how much freedom is there to do this? Well, I just think that's quite misplaced. I think this is quite reasonable accommodation. If you can't kill, you still owe some service to your country in some respect. We still do this today with conscientious objectors. They do alternate service of some kind. They're just not saying, well, you can go back to your cappuccinos, you know, in the village, something of that sort. So, and then the last one, again, it's also clearly directed at a particular religion, where I bolded, I hope it's bolded in the, I don't know whether it is, that the last part of it says, shall abjure and renounce all allegiance and subject to all and every foreign king, prince, potentate, and state in all matters ecclesiastical as well as civil. This created significant problems for Catholics. It was aimed at Catholics. The kind of double barrel thing that Jason talks about. He talks about papist or citizen. In this case, papist, clearly, because if you are a papist, you're going to have a hard time taking this oath. In 1821, things begin to change. Notice the religious toleration clause. Now, what happens here is as I point out at the end, the whereas material is eliminated. That screed from J that was put in there is now simply expunged. And what you get is a pure, if you like that phrase, example of a clause meant to give religious freedom to the citizens of the country. Section 4, the clergy of Belgium, they continue this, the clergymen not eligible. Notice what happens, however, to the militia, the Quakers here. Here, the movement, I'll jump ahead to the end of the story, the movement, the trajectory here is from the specific exception to the abstract or the generalized principle. You'll see this in the 1967 Constitution. Here they eliminate any reference to Quakers and talk about any religious denomination, whatever, as from scruples of conscience may be adverse to bearing arms. So the principle is expanded from an exception to Quakers to any religious body. The common law is continued here, the same thing in that one. So what we have here is the article involving, let me get it back here, now I've lost it. Involving the ecclesiastical oath is eliminated, and the whereas material that Jay had inserted is also eliminated. Finally, in section 1 here, the official oath, it says very clearly, no oath, declaration, or test shall be required as a qualification for any office or public trust. So you see a significant change here in the 1821 Constitution, the Convention. Then the next Constitution in New York, We've had 9 constitutional conventions and 4 constitutions, I mean, and almost 250 amendments. We've been pretty busy here in New York. And so this is a great depository of material to watch the layers of development that each generation leaves in the form of constitutional change. 1846, religious liberty, they keep that in there. Section 4, Article 7, prohibiting clergy from holding civil or military office, is removed. So by 1846, a great deal has been accomplished with those, what we now consider offensive provisions of 1777. 1894 is a watershed in terms of relationship between church and state, because it's at this point that the issue of the constitutionality of aid to religious education, mainly Catholic, comes to the Constitution of New York. It had been the tradition in New York. It's rather mixed and complicated, but by and large, the use of state aid had taken place in various forms in the late 18th and throughout most of the 19th century. Some laws preventing it, other areas allowing it. It's a rather complicated picture, but there was no clear indication that aid never did go to these religious schools. Schools, it did. And this provision, I'm sorry, let me jump down. The provision, I'm sorry, it's down on, I have 2 articles here. One of them is corporation charities. Notice what it does here in Section 9. It makes it very clear that aid to these institutions, whether religious or not, is permitted. This is going to turn, I'm going to explain, this is a grand bargain or compromise that takes place in 1800 between allowing the charities, which are mostly Catholic, the eleemosynary institutions, to continue to get aid and to perform their duties, at the same time adopt this, what is so-called, I think Green is right here, it's not particularly a Blaine amendment, but this no aid to denominational institutions in education. So it allows it here, and then it has 2 specific provisions about how this will work itself out. Look at Section 14. It says, whether under public or private control, that's the key phrase here, allowing for this aid, payments by counties, cities, towns, and villages to charitable, eleemosynary, correctional, and reformatory institutions, wholly or partly under private control or care, support, and maintenance, may be authorized, but, of course, not required. Now, these are important passages for preserving the power of the state to provide state aid to these institutions. Somehow it wasn't as dangerous to aid religious institutions that were taking care of the poor and the blind and the dumb and the like as it was to provide aid to education unmitigated by any of these other factors like charity and things of this sort. It was very difficult to argue against this, in fact, at the convention, although they did. So having accepted it in this area, and with the church's approval, clearly the church's approval, the hierarchy, they accepted the no aid principle for education, at least not as a matter of justice, but as a matter of political compromise here. And so you get this famous provision in Section 4, neither the state nor any subdivision thereof shall use its property or credit or any public money or authorize or permit either to be used directly or indirectly. They wanted to nail this down. In aid or maintenance other than for examination or inspection, any school or institution of learning, wholly or in part, under the control or direction of any religious denomination, or in which, I underline this, any denominational tenet or doctrine is taught. Now this gets into a fascinating area that I learned a lot about reading Jason's book and Hamburger and others. This distinction between religion and denomination, between sect and religion. And it was an absolutely essential one to those people who wanted to not give aid to Catholic schools, but who wanted to maintain Bible reading and the other kind of what one would call generalized or generic Protestantism that characterized public schools in the United States, certainly through the 19th, and in some cases right up through most of the 20th century. So we have court decisions in New York that explicitly say that there's a difference between denominations and this generalized Protestantism. That's okay, but denominations like Baptists or Methodist Catholics, that's not okay. And it survived the 19th century, at least in New York. In 1915, this constitution was rejected, but here, notice what they did with the conscientious objection clause. Subject, however, to such exemptions as are now or may hereafter be created by the laws of the United States or the it simply let the decision as to who would get exemptions to the legislature. More generalized. 1938 was the next major convention in New York, and they continued the no aid principle, but in the middle of the convention, the Court of Appeals handed down a decision, Judd versus Board of Education, in which they said busing of school children to parochial schools was unconstitutional. Now, this has to be under the state constitution, you understand, because the national constitution, we've not incorporated the establishment clause into towards the states. I think that took place in Everson. I think Everson is a decision that does that. So in the middle of the Constitution, the delegates, noting that, simply add to this provision, but the legislature may provide for the transportation of children to and from any school or institution of learning, overruling that decision. The last constitutional convention in New York was in 1967, in some ways the most revolutionary, I like that word, or modernizing constitutional convention we've had in this state. And the first thing they did, they removed that little Blaine Amendment. One of the most controversial things they did. Now, you would think by then that the era of Roosevelt and Cardinal Spellman with their controversy in 48, and Paul Blanchard's book, American Freedom and Catholic Power, and Joseph Blau's ostensibly academic, but in fact humanist credo in all these things took place in 1948. It was just, a lot of things were taking place. That era was the high water mark of tension between Catholics and non-Catholics in the United States. And I think it was to some extent, but in this decision to take this away, it raised a firestorm. Now the question is why? This provision has not been interpreted by the court to give any more protection or to give any more separation of church and state than the First Amendment does. New Yorkers have simply made their peace with this issue by and large. We have come to accept the fact that we're a diverse state, and to simply deny large groups of people on a principle that is of dubious origin, we're not going to do it. And so large amounts of aid in various forms is given to various religious groups, and the political system has come to that accommodation. And the courts have accepted it in New York. So the question is, why all the anger and the tremendous outcry about removing this provision? There can be only one explanation, I think. I don't know the answer, but I suggest is, in spite of the fact that it doesn't give any more protection, it acts as a symbol for significant parts of the state of New York. It's symbolic politics, I think, at its most obvious, that outcry took place. Others may have a different explanation. But notice what these delegates did. They replaced that with some fairly contemporary ideas. Equality of educational opportunity shall be guaranteed to all people of the state. The legislature shall provide the necessary programs to develop the educational potential of each person. In any law apportioning state aid to school districts, the basis of computing total number of students shall be the registration thereof, and such, this, all are mistakes which I didn't make because I just copied this, I don't know where they, shall take into account both the special educational needs, if any, et cetera, et cetera. 2, discrimination in the admission to any school in the state supported in whole or part by reason of race, religion, or national origin shall be prohibited. That was one of the reasons this Constitution, which in many ways was far-sighted, was defeated by the voters. It made some other missteps too, and the decision of the head of the convention, the President, Anthony Travia, to submit all these changes as a lump. You take it or leave it. We think that had he put these things down as separate propositions, much of the Constitution might have been passed, and these more controversial ones may have been rejected. But we lost everything. And we've been struggling as a result with a Constitution that simply is like a Potemkin village. It bears no relationship to what happens in New York, and for the most part. Thank you.
Thank you, Professor Gailey. Now, Professor Nelson.
I see why people are staying at the weird podium here. In 18th century British North America, it was impossible for Roman Catholics to practice their faith, except in a tiny number of very limited localities. Then in the 19th century, practice of the faith becomes possible almost everywhere in the United States, although discrimination against and hatred of Roman Catholics remain commonplace. Finally, in the second half of the 20th century, discrimination ended and Catholics became fully equal participants in American life. Why did these transformations in the role of Catholicism in America occur when they did? That is my question for this morning. In particular, I want to focus on what was special about the years around 1800 that resulted in ending what had been a collective paranoia about Roman Catholicism in most of Britain's 13 American colonies, a paranoia that kept Catholicism out of existence. New York City is a perfect example. In 1700, there were fewer than a dozen Roman Catholics in the city. Even in a city that tolerated Jews, Catholicism remained officially unwelcome. Anyone hiding a priest, for example, was subject to a fine of 200 pounds. 40 years later, a man named John Uri, a private tutor with expertise in Latin, was charged with being a Catholic priest and of leading a slave conspiracy, accused of practicing, quote, a hocus-pocus bloody religion. Uri was convicted and executed. 4 soldiers from the royal garrison, Peter Connolly, Edward Kelly, Edward Murphy, and Andrew Ryan, were also suspected of being Catholics and duly arrested. By the 1780s, change had begun to occur, with nearly 1,000 Catholics residing in the city. During the War of Independence, a Jesuit named Ferdinand Steinmeier had slipped into the city and celebrated Mass for the first time secretly in a house on Wall Street. After the Revolutionary War, legal restrictions on Catholic worship were eliminated, and Steinmeier gathered his congregation and said Mass regularly in a loft over a carpenter's shop on Barclay Street. The cornerstone of New York City's first Roman Catholic church, St. Peter's, was laid in 1785, and by 1806 there were some 10,000 Catholics in the city. But hatred, prejudice, and discrimination remained. In the 1830s, a nuns' convent in Massachusetts was burned. 2 decades later, the Know Nothing Party briefly sprang into existence. As late as the 1920s, the Ku Klux Klan burned crosses on the lawns of Catholic parishes that were being constructed on Long Island. And when New York's governor, Alfred E. Smith, campaigned for the presidency in 1928, he witnessed the burning of crosses by the Klan as he traveled around the country. It is difficult to imagine anti-Catholicism of this nature today, but it is only in our lifetimes that it has ended. So why the change? In particular, what happened in the years around 1800 that made it possible for Roman Catholics in America, much as they remained disliked, to attend Mass and otherwise practice their faith? The answer, I suggest, is that in the middle of the 18th century, religion was not primarily about God, but about political, economic, and social hegemony. The Protestant Reformation had not only been about the Catholic Church's corruption and about returning to the egalitarian moral values and organizational structure of early Christianity. It had also been about stopping the drain of German money to Italy and about making England, Germany, and the Netherlands independent of the Habsburgs. Think about the changes that the Reformation brought to England. Catholicism meant that the English crown was allied with Spain, first through the marriage of Henry VIII to a Spanish princess, and then through the marriage of Bloody Mary to the Spanish king. When Henry and then his daughter Elizabeth broke those alliances, Englishmen became free to trade with the rebellious Dutch and to plunder Spanish shipping. Arguably the most important effect over 2.5 centuries of Catherine's failure to bear Henry a son was the creation of the British Empire and the demise of the Spanish one. Think also about the changes internally in England. As a result of the Reformation and the destruction of the monasteries, vast tracts of land changed hands. Secular landlords probably were more entrepreneurial than monastic ones would have been, and younger men who went into the military or into trade had a far greater impact on spreading English power overseas than monks would have had. The destruction of the monasteries simply changed the structure of power in English society, and probably had more to do with the religious choices of English families than did faith in the religious primacy of either the Bishop of Rome or the Archbishop of Canterbury. Let us turn to colonial America, first Massachusetts. I do not mean to deny the religious impetus behind Puritanism, but Puritanism was as concerned with the political and economic organization of society as it was with God. It was as much a social philosophy as a set of religious beliefs. In traditional European society, political, economic, and social power had been based on bloodlines and inheritance. In Puritan Massachusetts, in contrast, power came from the intellectual attainment and commitment to community. The men who ran England were the sons of men who had previously run England, but the men who governed Massachusetts were those who participated with others in their community in discussing and interpreting the textual words in the Bible constituting the community's foundation stones. The struggle between Anglicans and Puritans was less about the vestments that ministers wore on Sunday and more about who could access power and how they could access it. To ensure that Puritans won the struggle in Massachusetts, only men who were full members of Puritan congregations were permitted to vote. Colonial Massachusetts was not unique in the connections it drew between religion on the one hand and political, economic, and social hegemony on the other. In South Carolina, Anglicans gained control of the government by requiring anyone elected to the legislature to take an oath before assuming his seat that he conformed to the Church of England and had not taken communion in any other church during the previous year. When Trinity Church was opened in New York in 1698, its vestry declared that the time had ended when, quote, for want of a temple for the public worship according to the English Church, New York City seemed rather like a conquered foreign province held by the terror of a garrison than an English colony possessed and settled by people of our own nation. And in Maryland, the Catholic Lords Baltimore appointed mainly Catholics to the bench and other high posts in government when they were in control. For example, 19 of the 27 men who sat on the Governor's Council from 1666 to 1689 were Catholic, and 15 of the 19 were related by blood or marriage to Lord Baltimore's family. But when, as a result of the Glorious Revolution in England, Protestants gained control of Maryland, an act of Parliament required office holders to take 2 oaths, one declaring that no foreign prince or potentate, quote, ought to have any jurisdiction or authority, ecclesiastical or spiritual, unquote, over any English dominions, and another proclaiming belief that there is not any transubstantiation in the sacrament of the Lord's Supper. The requirement of these oaths effectively excluded Catholics from office in Maryland, thereby giving Protestants political and, over time, economic and social hegemony as well. Perhaps the best illustration that I can give of the connection between religion and other forms of hegemony in the 18th century comes from a case out of Middleborough, Massachusetts. a townsman was sued for debt on a writ of capias, which meant that he was placed in jail. He asked the church congregation to put up bail for him. The members refused. The debtor, they declared, was not in good standing with the church, and therefore they had no obligation to assist him. He remained in jail. Religious pluralism was not an option for most 18th century British colonials. It existed in a few places such as New York City, but in most localities everybody belonged to a single church. Religious pluralism and toleration were an anomaly. Accepting Catholicism thus did not entail toleration. It meant changing religion. And changing religion meant not only that Sunday services would be different, but that the people who controlled the political, economic, and social life of the locality would also be different. The American Revolution broke the link between religion on the one hand and political, economic, and social hegemony on the other. When Protestants could no longer agree, and I think this is the key point, as they could not in the 1780s, about which sect would dominate religious life, and through it, political, economic, and social life, they created a competitive religious environment in lieu of a monopolistic one. In this new competitive religious world, a man could no longer gain control over other people by becoming a leader of a religious denomination. Again, I can illustrate with an example from a small town in early 19th century Massachusetts, where a young unmarried woman became pregnant. When the leaders of the local congregational church visited her and informed her that she would need to confess to the congregation and accept its punishment, they found they no longer had power. She informed them that rather than confess, she would go down the street and join a new and different church. Thus, the American Revolution was not simply a war of independence. It produced transformative social change in that it took power away from the lay leaders of local churches and transferred it to people who simply possessed wealth. The transfer was not a dramatic one, given that 18th century religious leaders usually had been men of wealth. Nonetheless, the transfer was significant because it made toleration and religious pluralism possible. In particular, in a world where church leaders as such no longer had power over other people simply because they were church leaders, accepting Catholicism no longer entailed change in the structure of societal power. The same rich people who had always controlled New York could continue to control it, while poor Catholics who no longer constituted a threat to those in power could be left free to practice their faith. But discrimination against Catholics persisted, and in part as a result, Catholics for over a century remained largely poor and powerless. It was only in the aftermath of World War II that discrimination ended. By then, two other changes had also occurred. One, as a result of the war, the U.S. economy for a time dominated the world. American enterprises needed all the talent they could get, including Catholic talent, and there was enough money around to compensate that talent without taking money from the established rich. Many Catholics became wealthy. Two, Catholics had internalized American values. They had learned to live in a competitive religious world in which they did not need to follow what the church commanded politically. As President Kennedy famously declared, he would take no orders from a pope or bishop. Catholicism, in short, had become American, and many Catholics, in consequence, attained positions of political and societal leadership. In conclusion, I suggest that we look back 300 rather than 200 years. In 1713, religion was a key element in the apparatus of social control. Changes in religion entailed change in rulers. Protestants could not tolerate Catholics in such a world. By 1813, the link between religion and social control had been broken in America, and new mechanisms of control, the capitalist marketplace and professional police, to cite two examples, had begun to emerge. Catholics could then be tolerated, although not within the ruling class. Only when Catholics had fully accepted the American norm of religious pluralism and competition, and only after John Kennedy had made that acceptance plain to the nation, could Catholics be fully accepted into the governing class.
Thank you, Professor Nelson. Professor Shelley?
Thank you. First of all, I'd like to thank Dr. Marion Casey for her kindness in inviting me to be part of this symposium. It's not often I find myself in such distinguished company. I've been warned to be brief, and I'll do my best to follow that advice. I always try to be brief ever since I heard a story about an after-dinner speaker in Ireland who failed to heed that advice. This person went on and on and on and wouldn't shut up. He drove everybody in the room to distraction. Or, since this was Ireland, he drove them to drink, literally. They drained every bottle of wine on the tables. Finally, one person could stand it no longer. He got up, grabbed an empty wine bottle, went up to the head table. He stood behind the speaker and took a swing at him with the bottle. But he missed the speaker, and he hit the person sitting next to the speaker. And as this person was falling to the ground, he said, "Hit me again, I can still hear him." I would not want to provoke an incident like that here this morning. I thought what I would speak about this morning is something different from the topics covered by my colleagues. Rather than talk about the legal complexities of People v. Phillips, I wanted to concentrate on the Catholic community in New York in 1813. And there are three aspects of that that I thought might be of interest to you. First of all, the origin and composition of the Catholic community. Secondly, the prominent role played by the laity, as is evidenced in the role of the lay trustees of St. Peter's Church. And thirdly, what I find really fascinating is this. It was the secrecy surrounding the sacramental confession that brought together Catholics and Protestants in that famous court case. I find that fascinating because two decades later, the secrecy surrounding confession was a major source of suspicion of Catholicism on the part of many Protestants. That represents a great change. First of all, the Catholic community in New York City in 1813. I would like to point out it was only 30 years old. Prior to 1783, Catholics could not organize and practice their religion publicly, as Professor Duncan and Professor Nelson have pointed out to us. It was only in 1783 when the British Army evacuated the city, and then the following year the state legislature repealed the anti-priest law of 1700. It was only then that Catholics could form and organize their own community. And it was the laity, not the clergy, who did that. In 1785, a group of Catholic laymen formed a corporation, acquired property from Trinity Episcopal Church, and started a subscription fund to build St. Peter's Church. And it's, notice I say it was the laity, not the clergy, who organized St. Peter's Church. There was no priest on the scene, and there was no Catholic bishop anywhere in the United States. It's pleasant to report that two of the people who headed that subscription list were George Clinton, the governor of New York, and James Duane, the mayor of New York City. Both of them were Protestants of Irish background. So it's the beginning of a friendship and mutual support between Catholics and Protestants in New York City that would surface again in 1813 with that famous court case. The first pastor of St. Peter's Church was an Irish Capuchin and a former chaplain in the French Navy, Father Charles Whalen. He estimated there were about 200 Catholics in New York City. Only about 20 of them were regular churchgoers. It was a surprisingly cosmopolitan congregation. Most of the parishioners, as you might expect, were Irish, but there were also, but Whalen said there were 6 languages commonly spoken by the parishioners: English, German, French, Spanish, Portuguese, and Irish. Despite the presence of a few wealthy merchants, most of these parishioners were poor. Father Whalen said they were not only poor, but desperately poor. That's borne out by the fact it would take 25 years before Catholics in New York would build a second church, what today is known as the Basilica of St. Patrick's Old Cathedral. And incidentally, the person largely responsible for that church was Father Anthony Coleman, the Alsatian Jesuit who figures so prominently in People v. Phillips and who was in many ways the real founder of the Diocese of New York. The New York Catholic community grew rapidly in the 19th century, so much so that by the end of the Civil War, the majority of the population of New York City, which of course then was just Manhattan, the majority of the population may very well have been Catholic. By 1880, there was a Catholic mayor in New York City. By the early 20th century, New York Catholics had acquired so much political influence that the Archbishop's residence at 452 Madison Avenue was commonly referred to as the powerhouse. But as Yogi Berra might have said, that was all in the future in 1813. In 1813, there wasn't the slightest hint, that the Catholics in New York City had such a bright future ahead of them. At the time of that famous court case, the Catholic community in New York City was small, poor, relatively powerless, and extremely grateful for the support that it received from friendly Protestants like William Sanson, DeWitt Clinton, and Richard Riker. A second aspect of this Catholic community I wanted to mention is the prominent role of the laity, especially the trustees of St. Peter's Church. And that may strike you as strange because it's so different from the scene today. But for the first 50 years of the American Republic, the Catholic laity were a power in the land, or at least in the governance of their own parishes. Virtually every parish had a board of trustees who were elected annually by the laity. I hasten to add the system was not as democratic as it may seem, because only the wealthier parishioners, those who rented pews, were able to vote in the annual election of the trustees. The reputation of the lay trustees has not fared very well in the history of American Catholicism. As you know, history is usually written by the winners, not by the losers. And in the struggle between the laity and the clergy in 19th century America for the leadership of the Catholic Church, it was the clergy who won, and won an overwhelming victory against the laity. As a consequence, until very recently, the history of the Catholic Church in this country has been written largely by clerical historians, and they either minimized the contribution of the laity or in some cases actually demonized them because of their role as lay trustees in their parishes. For example, the first real history of the Archdiocese of New York appeared in 1908 on the occasion of the 100th anniversary of the diocese. It was written by a local pastor named John Talbot Smith. He vilified the pew holders who elected the trustees in the strongest terms. They very often professed the faith with their mouths but lived the lives of pagans, Talbot Smith said about these people. He said, these parishioners were filled with heretical notions and admired ultra-Protestant customs. That would not be, well, it's extreme, but it's not, so totally out of the mainstream of the way the lay trustees were presented in American Catholic history. In 1983, a popular history of the Archdiocese was written by another New York priest Florence Cohalan. In his treatment of People v. Phillips, he never mentions the trustees for St. Peter's Church. He attributes the favorable outcome entirely to Father Coleman. He never mentions the trustees. I would say that's clerical history with a vengeance. Lay trustees have often been criticized for their harsh treatment of their parish clergy, but in some instances at least, their harsh treatment may have been justified because of the unsavory character of some of these priests. In 1837, for example, Bishop John Dubois, the aging French-born Bishop of New York, asked the coadjutor bishop in Philadelphia, Francis Patrick Kenrick, to come to New York and serve as his coadjutor. Kenrick refused, and the reason he gave was this. He said he had dismissed a number of priests in Philadelphia. He fired them, and Dubois had taken them into New York. He said, I don't think they would be happy to see me come to New York. And he also said, this is in a letter to Paul Cullen, the rector of the Irish College in Rome. He said he had dismissed these priests ob crimina, because of criminal misbehavior. Or consider the situation in St. Joseph's Church a few blocks from here. St. Joseph's Church on 6th Avenue, it was the scene of many conflicts between clergy and the lay trustees. At one point, the parish was placed under interdict. But the blame may not be entirely due to the lay trustees. For example, in September 1845, John Hughes fired the pastor of St. Joseph's Church, the ineffable Ambrose Manahan, and he sent him a classic letter. He said, I advise you to ask for your exeat and to get out of my diocese as quickly as possible. He said, in the almost extinguished hope that on a new scene, where your future character will be determined by your future conduct, you may disappoint the melancholy anticipations that the past is too well calculated to inspire. I'd say that's a mouthful. In recent years, historians like David O'Brien, who taught for many years at the College of the Holy Cross, and Patrick Carey of Marquette University have set the record straight about lay trusteeism. They pointed out that in many places the system worked very well, and it gave dedicated laymen the opportunity to make a valuable contribution to American Catholicism. One of the many valuable features of this symposium, I would suggest, is the fact that this symposium has reinforced this revisionist interpretation of the role of the lay trustees by pointing out the prominent role they played in that famous court case in 1813. In New York, the role of the lay trustees was effectively quashed in 1838 with the appointment of John Hughes, who as the assistant to the aging French bishop, John Dubois. Hughes became an iconic figure in New York Catholic history, and rightly so. He was rightly revered by his immigrant flock because of the way he defended them and championed their interests against nativist bigotry. However, there was also a dark and unpleasant side to Hughes's character. Hughes was a born autocrat who would tolerate no opposition from either the clergy or the laity. He told the clergy at one clergy conference, if you want canon law, then go to France or Spain where it exists. He said, here I am Lord and Master, and we don't need canon law. When two Irish priests complained that he had violated their rights in canon law, he said, I'll teach you County Monaghan canon law and send you back to the bogs whence you came. It's funny, but it's not funny. John Larkin of the Society of Jesus, the president of St. John's College at Fordham, he said of Hughes, I quote, he is a violent man and a stubborn one, and neither reason nor law have any weight against his will. It was only a matter of time before Hughes had a clash with the lay trustees, and the blow-up occurred on Sunday evening, February 24, 1839, in St. Patrick's Old Cathedral, before a gathering of some 600 people, including the trustees of the cathedral. The background to this meeting was an incident that occurred 2 weeks earlier, when the trustees of the cathedral called in the police to remove a Sunday school teacher from the classroom, a Sunday school teacher whom Bishop Dubois had appointed. You said to Dubois, you can't stand for this. He said, if the trustees can remove a teacher from the classroom, they can remove a priest from the sanctuary. The upshot 2 weeks later was this meeting in the old cathedral before 600 people. It was the kind of scene that Hughes loved. It gave him the opportunity to do two things he loved to do, to talk and to fight. He went right for the jugular. He compared, and it was, shameless demagoguery. He compared the trustees to the British authorities in Ireland. And he said, he told his listeners, the sainted spirits of your ancestors are looking down on you from heaven. They're ready to disavow and disown you. If you allow pygmies among yourselves to filter away the rights of the church, which your glorious ancestors would not yield but with their lives to the persecuting giant of the British Empire. You get the drift of his remarks. It was sheer demagoguery, but it was very effective. Hughes said by the time he finished speaking, many of the people were weeping like children. And here's the real kicker. And then he said, I wasn't far from tears myself. That's after listening to his own rhetoric. Say the result of Hughes's performance was the rout of the trustees of the cathedral parish, and shortly thereafter, the end of lay trusteeism in New York. I don't mention this to praise Hughes, but to criticize him, because of his overbearing authoritarianism. He had a legitimate grievance against the lay trustees for firing this Sunday school teacher, but he turned it into a full court press against the very existence of lay trustees. By rejecting any collaboration with the laity, he made it virtually impossible for them to do what the trustees of St. Peter's did in 1813 in that famous court case. Let me finish. I said that it was ironic that the defense of the seal of confession was the issue that brought together Catholics and Protestants in 1813. 20 years later, a full-blown anti-Catholic movement was sweeping the country, much of it fueled by the huge number of Catholic immigrants. And that continued until the Civil War. The most famous historian of that movement, Ray Allen Billington, he called it the Protestant Crusade. And he identified the 1830s as the decade that saw the emergence of these professional anti-Catholic bigots. And there were two things they zeroed in on to arouse Protestant suspicion of Catholics. One was convents, the other was confession. Both of them were shrouded in secrecy, both were unfamiliar to Protestants, both could easily be portrayed as centers of debauchery. Bogus nuns appeared on the lecture circuit describing the horrors of convent life. Perhaps the most famous of those impostors was Maria Monk, whose Awful Revelations was published here in New York City in 1836. It sold 300,000 copies before the Civil War. Billington referred to it as the Uncle Tom's Cabin of Know-Nothingism. Along with these stories of the immoral activities in convents, want the stories about confession and how the secrecy of confession was a veil for priests, to seduce innocent young women. By the 1830s, a gullible public readily believed much of this propaganda. They came to view confession as an intrinsically evil institution that demanded government intervention to protect defenseless females from rapacious Romish priests. It was a very different world from the world that produced that famous court case in 1813. At this point, I think a quotation from Scripture would be appropriate. I would like to make my own the words of the risen Lord to his disciples when he said, I have many more things to tell you, but you cannot bear them now. Thank you.
Our speakers have been so disciplined and eloquent that we have time left for some questions, if anyone from the floor would like to ask one? Floor's open.
There'll be a quiz.
Perhaps Martin Burke, I was interested in I've been too involved this year in getting the play produced rather than actually reading part of the history. And I know Walter will probably talk about some of this, but I was sort of fascinating as to, because Marion found an ad for the book, The Catholic Question, in, was it Baltimore? And I was just wondering what else was known about this publication at that time in 1813, and why did he do what he did, and how broadly publicized was this case and Sampson's effort in it?
I'll defer to Professor Walsh in terms of the legal publicity. But if one goes through newspapers, magazines, and book publication advertisements, as Marion has, there certainly were copies of the text available at primarily Catholic booksellers in Baltimore, in Charleston, Louisville, New Orleans. All seem to be variants of the New York imprint. Generally what one does, this is stereotyping, has not been introduced yet, so what one does was simply buy the text and put a different imprint cover on it. But the people who seemed to pay most attention to it were Protestant clergy rather than the general public. And as I said in my remarks, they seem to be a lot more concerned with the Coleman section, which is much larger. Coleman's 112 pages, I think Marion counts everything at 125 pages, but it's in much smaller type than the typeface for the Sampson's record. And I could find in newspapers or magazines simply no reference to the trial qua trial, but the Coleman piece got a lot more input. Professor Walsh has pointed out, and thanks for doing the research, that there's a Dublin imprint of the Catholic Question done subsequently. That doesn't contain Coleman's brief exposition on the sacrament of penance. I guess that's irrelevant in Ireland in the 19th century. There is a Manchester, UK imprint of Coleman's section done in the 1820s, which is detached from the Sampson trial transcript. But if one is a reader, you're mostly going to see a reference to the People v. Phillips in the context of Coleman rather than the context of William Sampson.
Okay, I'm going to make some point about this. I wasn't going to, but it's very interesting about publicity. New York has kind of the Bible of constitutional stories, a man named Charles Zebrina Lincoln. He wrote a 5-volume history of the New York Constitution, and everybody relies on it. He was a delegate at the 1894 convention, and he compiled this massive document, which is considered quite genuine and legitimate and scholarly. And after reading the article by Professor Welsh, I went back, because he has the Constitutions annotated. I mean, he annotates everything. He's very careful about the cases. And I went back to these provisions. It's not mentioned. It's not mentioned, and it's kind of disturbing to me, because students of the New York Constitution and the should be aware of that. I mean, we rely so much on him, it's just not there. And in my treatment and other treatments, there's no mention of it. I hope I get another shot at the revising this Constitution before I die, because I certainly would do some significant revision in terms of this particular clause of dissension, but it's not there, and he's not one to be that careless. I don't know why.
Are we allowed to ask questions of each other? So I have a question of my fellow panelists and maybe Walter. Certainly, the lay trustees are vitally important because I don't think the church or a clergyman could hold title to the physical structure of the church in 1785. Under New York law today, the Catholic Church holds title to property as a corporation sole, but that possibility didn't exist in 1785. And the question I've got is, when does it become possible for the clergy to effectively take over title to the land? I assume that's by an act that becomes possible by virtue of an act of the New York legislature. I would have a suspicion that Archbishop Hughes was terribly important because he was a very politically effective man in getting that legislation passed. But I'm wondering if any of you know, because that would be it would be that legislation that would effectively make lay trustees unnecessary and wipe out their power and transfer all power to the clergy. But does anyone know when that's enacted and what the politics of it was?
I don't know the exact date, but I suspect it was during Hughes's time. But my understanding is today, in this archdiocese at least, every parish is a corporation, and it consists of 5 people. The president is the archbishop, the vice president is the vicar general, the pastor is one of the trustees, and the other 2 trustees are lay people. So in effect, the archbishop controls 3 of the 5 votes.
As I remember, I'm trying to, I believe there's a flurry of activity that takes place both with regard to court decisions and legislation around 1850, I think, in New York. That would be, when is Hughes? He's about that time, isn't he? I mean,
He was here from 38 to 64.
And if I could just chip in here, so I think you're very much right about this bill, and it was the case that the clergy could not hold the property, and this was under New York law, and because of this, it created a legal structure where the trustees were very powerful, and they used that power, and as you heard, that caused some friction. And it has been superbly researched by John Peter Gilday, who wrote a series of superb articles on this, so it is very thoroughly documented. I don't have the specific date in my head, but I think the time when this declined is somewhere about the Hughes period that you mentioned. And if I could mention a couple of other things. First of all, both Professor Burke and Professor Gailey both mentioned the importance of the state constitution in this case, and it certainly was that. It's important to realize that Sampson did explicitly make an argument also based on the US First Amendment. And not only did he make it, but it is actually incorporated into the opinion of Judge Clinton, Mayor Clinton in the case. It's very interesting because it was exactly 20 years later that the US Supreme Court, in a case called Barron versus Baltimore, first addressed the question whether the Bill of Rights, the first 10 amendments, did apply to state action, including, for example, the First Amendment. And they said no. And it wasn't until after the adoption of the 14th Amendment, and indeed its incorporation well into the 20th century, it was really the 1940s that you begin to see the US First Amendment being applied to state action. But it's impossible to say that Phillips was wrong in this because it was decided before any of that. But the Supreme Court went in a different direction later. But it's interesting in that way. And then just a rather interesting point I'd also bring up from Professor Shelley's presentation, which is that you mentioned Ambrose Manahan, and I cannot resist sharing with you. What was the date of the time you mentioned his expulsion?
It was September 1845.
Okay, well, he made a bit of a comeback of sorts, oddly related to this case. because in South Bend, Indiana, I dropped into the Notre Dame Library, and completely unexpectedly, as I combed through the catalogs there, I saw a reference that I had never seen before, and I rooted out this beautiful book, which it's a beautiful typeset, printed and bound, annotated 1867 reprint of the Phillips case. It's beautifully annotated and done. It's a very lavish and very beautiful work. What's odd about it is that, including indeed more than Sampson's original report, so it's a true labor of love, and it includes, among other things, for example, a biography of Father Coleman, and it is called the opening volume of Manahan's American Catholic Museum. It's dated 1867, and inscribed in pencil on the flyleaf is this following note. This book was never published, and there were but 6 copies struck off, of which this is the only one, I believe, that was preserved. The author, Reverend Dr. Manahan, died just as the book was being stereotyped, and as none of his relations saw fit to pay the printer for his work, he struck off 6 copies, one of which was sent to me to see if I would purchase the plates. Not choosing to invest, the plates were melted up by the printer. So this is a printed book that was never published, and it's signed in pencil by L. Keogh in November of 1872. So it might have thrown it back into the public domain, while it is important to note it had a continuing legal jurisprudential currency, and through this period, the priest-penitent privilege ultimately became the rule in America. But it did disappear for a period from public view.
I wasn't aware of that. He did publish a book, a theology book, that Orestes Brownson thought very highly of. But he also said about Hughes, he was a tyrant, but with a heart.
I'm not sure if that's a happy or a tragic note to end on, but please join me in thanking the panelists. And I believe we have a short break, and then we're back here at
in half an hour.
In half an hour at 11:30 promptly. Thank you so much.